I've got an offer that I presented, and the buyer sent it to her attorney. It was a good offer. It was on our CBA contract, big contract that the state puts out. It's a 20-page deal. It's a long contract. So I wrote an addendum to it, just clarifying an addendum, right? All the details. And then the buyer decided she'd send it to her attorney. The attorney returned it with an additional addendum, basically taking all of my 19 points on the addendum and putting attorney's in them, exit strategies, off ramps, you name it. Took every good thing out that was there that was for the seller. And made me mad, actually. I don't know if you ever get mad when you get one of those, but I did. I got frustrated. I had to settle down. But I'm wondering how to respond, actually. I've responded to her nicely and thoughtfully. Her last response to me while we were sitting here was, this contract looks like a real estate contract. And she's fussing over the LLC that happens to be in there, and the taxes were represented as an LLC. And I said, well, no, it's not a stock sale. It's an individual that owns all the stock. She's given you all the assets. She's not selling you stock. But I think what has happened, that the attorney has looked at this thing and has said, I'm confused. I think this is a stock sale, and has decided it's a stock sale. And I'm not sure how to respond. I've responded already and said, no, it's an asset sale, as basically and as clearly and as cleanly as I can. Her comeback was, well, it says LLC on the tax returns, which is okay. Yeah, of course it does, because that is how people report their business taxes. And
Right. Well, and the LLC owns the assets. So I would just make sure that the LLC is the seller on the contract, because the LLC is selling the business assets. I mean, if it were the individuals selling their membership interest in the LLC, the individuals would be the seller. Or if it were a corporation and they were selling the stock, then your individuals, John and Jane Doe would be selling 100% of the shares of the stock of XYZ Corporation to, Bob Smith or whatever. In this case, the business is an LLC, or the business entity is an LLC. So it's the entity that owns all of the assets. So the entity has to be the seller that's going to sell those assets. Because if you say, John and Jane Doe are selling, ABC LLC, then that is going to imply that they're selling their membership interests in the LLC.
So the way the contract was written was that her name, John Doe, Jane Doe / business LLC, is selling the assets, and that's where the confusion started, I think.
Because her name is there.
Name shouldn't be there. Yeah,
she's the authorized signer for the LLC in her capacity as manager or member, depending on, or whatever. I mean, LLCs can also have officers, so whatever her capacity is, but she should be listed as an authorized signer or signing on behalf of the LLC using her title from her, whether she's an officer or not. But I would take her name off, because it's the LLC that owns the assets.
Easy to do. But it's not a stock sale, and I think that's where the confusion was. And so,
well, there's no stock in an LLC.
There is no stock.
It's either a membership interest. But there's no stock per se.
So anyway, the attorney has got a lot of legalese in there. I'm not sure how to respond to that. How you've had this happen to you?
So you represent who? The seller or the buyer, or both?
Seller.
You represent the seller.
Well, both.
Okay. And this attorney is working on behalf of the seller or the buyer?
The buyer.
The buyer. So usually what I do when a buyer's attorney gets a little too aggressive is I just have a meeting. I just have a phone call with the buyer and I say, look at, um, you need, first of all, I don't know what kind of attorney it is. It could be a transaction attorney or could be a divorce attorney, right? We never know who hire
Yeah,
when they
that's
hire
right.
an
That's
attorney.
right.
It could be their friend who specializes in, family law. So you really don't know. But what you can say is, look at you need to give the attorney a scope. You are the client, and as the client, you need to tell the attorney, you need to give them a scope of what they're supposed to do, because otherwise they're going to go to town and do all kinds of things that you don't need them to do, which is just going to
Yeah.
run up a lot of fees. So what I try and tell them is the attorney's job, as I see it, is to identify the risks to you as the buyer. Just point out the risks. And so identify those risks, and then it's your job as the buyer to determine which of those risks you are willing to accept and which of those risks you want the attorney to try to mitigate to the extent possible without killing the deal, right? Because attorneys, especially litigator mindset is win lose. You go to trial, there's no tie, there's no win-win at trial, right? So you have a trial, one party wins, the other party loses. It's an all or nothing. In a transaction, it can't be an all or nothing. It has to be a win-win, or you're going to end up in trial afterwards, right? So
Right.
it's really important to convey to the buyer that, look at, we're looking for a balanced contract. Your attorney cannot make this so one-sided and onerous that it puts you in a bubble with zero risk and zero liability at the expense of the seller, because you're never going to get a transaction done that way.
Yeah. Yeah. Well,
And
every
and
point.
then just tell the buyer, it's like you have to tell your attorney what the scope is. So tell them, point out what the risks are to you. Some of those risks you're going to be willing to accept, and others you're not, and that's fine. But give your attorney some direction and a scope so the attorney doesn't completely kill this deal.
Yeah. Yeah.
Mm.
Okay. That's good
Thank
advice.
you. Yeah, thank you so much, Tanya, for that advice. Yeah.
Yeah.
Yeah, that's what I have to do. This is a corporate buyer. She comes from a huge corporation,
Hmm.
and she's buying a dinky little company that the founder runs right now. And the
Yeah.
founder says, "I don't even want to read this. I don't
Yeah.
want to read this," and it was making her mad. And
Yeah.
well, I tried not to stir her up, but it's going to kill the deal, as you pointed out, if we can't mitigate this properly. So
Yeah.
what do you ever say? Listen, put yourself in the seller shoe a little bit here. How would you feel if you got this? You ever say anything like that?
I always, actually, to buyers and sellers both. I mean, with
Yeah,
sellers, I'm always trying to tell them, hey, stand in the shoes of the buyer, look at your business from their standpoint. You as a seller know your business inside and out. Buyer is looking at it from the outside, not knowing anything. And so that's why we have to provide them with a lot of documentation, a lot of information, and all that. To the buyers, same thing. It's like, look, you want to make an offer that is that's below the seller's asking price, that's fine, but you need to give me um, this the backup and support that I need to be able to sell your offer to the sellers,
yeah,
because the asking price was, they can substantiate the asking price. They provided all the documentation to substantiate that. So I need to be able to go back to them and explain to them why you're coming up with the number that you're coming up with, stand in their shoes. I mean, so yeah, absolutely. You've got to have those
well, the number is
conversations.
not the problem. We've got the number. We've agreed
Right.
on the price.
Yeah.
It's
No,
all of
in
the
this case, it's the attorney. And so what
yeah,
you have to do with the buyer, say, look at, your attorney is probably used to doing 50 million, $100 million deals. This is not that. Small business sales are very different. How they're
Yeah,
handled is very different. You can't, no, the seller is not going to pay $200,000 in attorney's fees to get this business sold. And that's really what
yeah,
what your
exactly.
attorney is forcing at this point is for the seller to go hire an attorney to review all this and redline it back. And the seller is not going to do the back and forth because it's too
No,
costly and it's
no,
not of interest to them.
no. Good advice. Good advice. Thank you for the last minute of your meeting today.
Can, can I also say that I think the addendum to the LOI can be a very great friend to you. You know, the more you can spell out in like the addendum and take a lot of the guesswork out of it, I think the more you can save people lawyers fees, I found.
Yeah, but and Dick said he had an addendum on there, but then the attorney basically rewrote his addendum into legalese.
Oh,
And this
gotcha.
is
Yeah.
an LOI, Miles. This is not an LOI.
Oh, oh, gotcha.
This is a PSA, and we just skipped the LOI because it's too
Because you're
small.
a licensed state. So
Yeah,
Miles is in a non-licensed state, so
yeah.
he can't skip the LOI.
Sorry, Miles.
Oh, man, I wish sometimes, man.
I know, right? So yeah. So in Montana, the attorneys have to draft the purchase agreements. So yeah, it's an interesting challenge in some
Yeah,
of these, especially when you're dealing with attorneys that are doing, 50 and $100 million deals. It's a completely different your stock purchase agreement. Like I did one, the stock purchase agreement was 38 pages before it got to all the schedules. And then it had a whole bunch of schedules on top of that. It was insane. So
I hope you made
yeah.
a commission out of that.
Actually, I was consulting for the seller because and whose advisor was largely absent, and so she hired me to consult with her and help her get that transaction finished up.
That's
So we
wonderful.
got it done and buttoned up. So it was good. It was good.